All right, guys, this courtroom session kicks off with immediate tension as the judge calls the case and the defendant challenges the system right away. Instead of following procedure, he insists on bringing in his own tribal counsel, refusing to accept standard legal rules. The judge firmly pushes back, making it clear only licensed attorneys can represent him, setting the tone for a confrontation that's far from over.
All right, good morning. We are on the record in the 53rd Circuit Court for the County of Sheboygan, and we provide public access both in the courtroom and also online. And, first up, we've got the case of People of the State of Michigan versus Trevor McLeod, file 23-6748-H. Mr. McLeod, good morning. Sir, would you step behind the bar, please?
He's by counsel.
He's not a licensed attorney.
Do we have I demand my right to counsel.
Sir, step behind the bar or you're going to be taken into custody. You're not an attorney, so gather your things. You can step behind the bar. I'll be in a minute. So, Mr. McLeod, I first have to establish that you told me before that you wanted to represent yourself. Are you changing your mind on that matter?
I'm bringing in my own counsel for the tribe, yes.
Is he an attorney licensed in the state of Michigan?
He doesn't have to be.
Yes, he does to practice in this court. So you're not wanting to represent yourself then? Am I hearing that correct? You want an attorney?
I have a right to counsel.
Yes, you do.
Doesn't have to be a licensed attorney.
Yes.
No, it doesn't.
In a courtroom, who do you think gets to decide that question? You or me? So me. And so you may be represented by an attorney, but it has to be a member of the bar of the state of Michigan. Now, I can tell you, I read your motion and Mr. Delpy's purported appearance, which is not authorized. And it seems to me that perhaps you want him just to explain some things to the court about the consent decree.
That's right.
Now, for that purpose, in your motion, you may call him as an expert witness on the question, and he can offer testimony on your behalf as a witness.
Okay.
But I can't allow him to make arguments on your behalf or represent you in the case.
Well, that's why we put it in for limited.
Okay, so you just want him to offer some testimony about that stuff?
Sure.
Okay, so we can do it that way, and he can testify as a witness. There's no problem. Assuming that he meets the requirements for a witness and, you have to follow the rules of evidence and all that.
Sure.
All right. So with that in mind, then, I need to confirm, are you still desiring to represent yourself?
Yes.
Yes, you are. Okay.
As the hearing moves forward, the defendant confirms he will represent himself, raising the stakes even higher. The judge carefully outlines the process around the motion to suppress, but friction builds when the defendant begins accusing a key witness of perjury before testimony even begins. Despite the claims, the judge allows the prosecution to proceed, signaling that arguments must be tested through questioning, not assumptions.
All right. So we are here on your motion to suppress. There is in the court file a preliminary examination transcript, so I did have an opportunity to review that, and I'll take judicial notice of those proceedings. So then I suppose we can take supplemental proofs. So Mr. McLeod, I guess, at the preliminary examination, the conservation officer testified about his actions and observations that day. Did you wish to have him offer further testimony about that, or do you want me to just rely on the transcript of the preliminary exam?
I think we have to rely on the transcript.
Okay, Mr. Juliet, do you wish to supplement that in any way, or
just very briefly? And I believe he's on Zoom for testimony. That's okay.
Okay. Any objection to that, Mr. McLeod?
Yeah, I object.
What's that?
I object.
What's the basis for the objection?
That his testimonies, I've already got proof of perjury here.
The prosecution calls a conservation officer to the stand, and the narrative begins to take shape. What starts as a routine stop for expired boat registration quickly escalates into something more serious. As the officer explains how the encounter unfolded, the defendant interrupts with objections, claiming the story is being changed, but the judge overrules him, allowing the testimony to continue.
Well, that doesn't tell me why he shouldn't be allowed to offer some additional testimony.
Because it's not valid. You can't trust it. He's already lying.
He's what?
He's lying.
Well, again, that's a different problem. I mean, if a witness testifies falsely under oath, that's serious problems for the witness. But the prosecutor's saying they want to offer some additional testimony by the correction officer. So I'll allow that, and then you can cross-examine them, and then you can present witnesses in their own defense. Good morning, sir. Can you tell me your name?
Alexander Bourgeois.
Thank you. Where do you work?
I currently work for the Michigan DNR in the Law Enforcement Division.
And how long have you been working there?
Since August of 2022.
Were you working on September 4th of 2023?
I was.
And are you familiar with the defendant in this case, Mr. McLeod?
Yes, sir.
Did you have contact with him that day?
I did.
And what was the reason for the contact?
We originally made contact with him because he had expired boat registration on his vessel. Upon making contact with him, it led to the arrest of him for boating under the influence.
Now the officer provides detailed observations that intensify the situation. He describes the defendant struggling with basic coordination, stumbling off the boat, and showing clear signs of impairment. Each detail adds weight to the prosecution's case. Even when objections are raised, the testimony continues, painting a picture that suggests this was far more than just a minor boating issue.
Okay. Was there anything else that drew your attention to the defendant?
Yes, we originally made contact with him at the boat launch.
Hang on. There was an objection. What's your objection to that question?
They're trying to add testimony to the statements in the original testimony. That's not stated.
Well, that's
trying to change the story.
Okay. Well, they are allowed to present, testimony here today, and I agree that's exactly what they're trying to do. They're trying to supplement the record and give you some additional information that wasn't in the attachments or in the prior transcript. That is permissible, just like you're going to be able to offer further testimony from what you gave in the district court. So I'll take all those things into account. So that objection's overruled. Go ahead.
Tensions peak as objections fly, and the judge is forced to step in repeatedly. The officer's testimony briefly goes beyond the question, prompting the judge to strike part of it from the record. But the key answer remains. Then comes the shift. Control moves to the defendant for cross-examination. His first question is simple but loaded, signaling that the battle in this courtroom is just getting started. Like the video, subscribe to the channel, and we'll see you in the next video.
So I'll just repeat myself, sir. Was there anything else that drew your attention to the defendant?
Yes, when the defendant docked at the dock along the river, when he got off the boat, myself and the other conservation officers, we realized that he had difficulty getting off the boat, that he had to hold the post to get off of it. Once he had gotten off of the boat and he walked towards the bathroom, he stumbled and swayed up the dock and ramp, and stumbled and swayed on his way back. That's when I made contact with him about the boat registration. And once I asked for the registration for the vessel, which obviously would be inside of it, he struggled to put his sandals back on longer than a normal person would. It took him about 10 seconds to put on a simple sandal. And then once he got into the boat, I noticed that he had lack of fine motor skills that would be common with somebody that's under the influence. I noticed that he had slurred speech. And then he also, I could tell that he showed just general signs of someone that might not be completely sober.
Okay. As part of your training as a conservation officer, do you receive any training in OWI related boating incidents, I guess?
Yes, we're trained in both normal motor vehicle, and then I myself am trained in BOI.
Okay. And before you, I guess, approached, can you explain the timeline of events? Did you notice any signs of intoxication before you made contact with the defendant?
I object.
Hang on, there's an objection. What's the objection?